When do you need legal advice as part of an RIA transition? That is today's question on the Transition to RIA question and answer series. It is episode number 145. Hi, I'm Brad Wales with Transition to RIA, where we help you understand everything there is to know about why and how to transition your practice to the RIA model. If you're not already there, head on over to transitiontoria.com, where you can find this entire series in video format, podcast format. There's articles, there's white papers, there's a vendor profile series, all kinds of things to help you better understand the model. Again, transitiontoria.com. Okay, in today's episode, we're going to be talking about a very important topic that is applicable to pretty much every transition. By the title of the episode, this is as if you're going into the RIA model. A lot of these topics are applicable if you're making a change within any of the channels within this industry, but certainly we're going to talk about with respect to the RIA model. And so where that is the question comes back to is, okay, do I need legal advice as part of the process of transitioning my practice from wherever I am now into that RIA model? And the reality is, and I talk a lot in these episodes about this, there are a lot of steps that go into this whole process, both from first learning more about the RIA model. Is it even something you should be exploring? Will it even be a fit for your practice? Are you going to accomplish what you hope you will accomplish by moving to it? So everything from that first step to understand all the pathways that you could take into the model, and then ultimately all the different pieces that you have to put into place. Now, one of those pieces is to get legal advice to help you with the departure from your current firm. Now, long run, there might be instances where you need or want legal advice related to that going forward state or the operation of your RIA or whatever the case is. But in today's episode, what we're primarily talking about is, do you need legal advice to help you navigate the departure from your current firm? Now, the short answer with that is in almost every instance, the answer is yes. Now, some of you might be thinking, well, I'm already independent. I'm at an independent broker-dealer. I don't need legal advice. And so part of what I wanted to do with this episode is to show where, okay, even under those quote-unquote independent scenarios you might be in now, it's still advisable to get the legal advice. And for those of you that are a more captive W-2 type environment, as some of the topics I'll be addressing here, you certainly will understand why you want to have that legal advice. So the short answer is yes, you generally will always need and want that advice. What I want to go over in today's episode, is to give you some of those variables that will drive the need to do that. Now, my goal here is to not scare you off of making a transition by pointing out all the legal ramifications or things you want to make sure you navigate correctly. What I wouldn't mind doing, if that's what it takes, is to scare you into accepting the fact that you should get this legal advice, but it is a tried and true process, and provided you get good legal advice, I'll talk about it towards the end, how you can go about doing that, that this is a process that can be navigated, but again, you want to get that advice. So I want to give you several variables, several reasons you might need this legal advice, and that are often part of the conversations is talking to an attorney. So the kind of biggest one, the one that generally always comes up first, is, okay, do you have some sort of agreement you've signed with your current firm? And in pretty much every instance, there is some sort of agreement out there. Again, whether you're W-2, say Wirehouse, or you're in some sort of independent broker-dealer. In all my years, the only time I've come across where some agreement, apparently from at least what the advisor's recollection is, was not signed, is they are with some very small firm or whatever the case is, and arguably due to sloppiness on that firm's side, that firm never had the advisor sign something kind of memorializing the affiliation. And that's the only time I've seen it where it appears to have ultimately not ever existed, was because of sloppiness. So again, in almost every instance, there is something you did sign at some point. And so there's many clauses in those agreements that you want to be aware of. And again, this is where an attorney can help you kind of navigate. And so I'm going to name some of them. Some of them will apply to some of you, and others not the case. But there's a couple or several here I want to just touch on quickly. So a common variable that's in agreements is a non-solicitation clause. Now, there's a lot of firms out there that you could be at right now that is boilerplate language that they have an agreement is the non-solicitation. If you leave, you cannot solicit your clients when you leave. That's, of course, a whole rant I could go on and how or why you'd ever want to be at a firm where after you've gone out and found clients over the years or decades that now if you were to leave somehow, those aren't your clients to be able to essentially solicit to bring with you to another firm. That's a whole separate topic. Again, I could rant about that nonstop, that alone. But the idea is that typically there is non-solicit language in there. And that, and just like many other things I'm going to go through here, are not deal breakers. That's not a dead end, but it is saying, okay, hey, if that language exists, how are we going to safely navigate it? And again, that's where it comes back to the conversation with the attorneys to say, okay, what is the proper way to make sure I don't run afoul of that language? So non-solicits is a very common variable in there. Others of you might have non-competes. Now, non-competes are less frequent. Several states have kind of planted a flag in the ground that says they don't really recognize non-competes, or they say they're anti-competitive. And so it depends on what state you're in. It could have different ramifications. But there are times that non-compete language is in there. And sometimes it's as simple as, hey, you can't compete within a 10-mile radius for a 12-month period of time. Others, it's very harsh sounding language that you can't almost compete indefinitely. And the good news is that sort of thing is generally going to get discarded or thrown out if there ever was some issue, because that's usually the precedent has shown that is way too onerous to expect someone to have to follow. But nonetheless, again, there could be non-compete language that you want to understand what's in your agreement and understand what your options might be with it. An even further restrictive variable, and this is even less frequent, but it does happen from time to time, is non-client acceptance, where somewhere buried in your agreement might not only say, hey, not only can you not solicit clients, on the chance those clients reach out to you on their own, you can't accept them as a client of yours. So that's pretty rare. Now, where you typically see that is if you have sold your practice to some buyer. It's quite understandable that the buyer of your practice is going to have some of this language in there, particularly perhaps a non-client accepts language. And to be honest, that's fair. If you are selling your practice to someone else, just as if you were on the other side of that coin, it is fair for them to say, hey, we're going to provide you monetary value for this. You can't take our money and then 6 months, 12 months, wherever, set up shop and then try to steal the clients or take the clients, or if the clients reach out to you, we expect you to say you cannot help them. So that's typically where the non-client acceptance comes in, is if you've sold a practice. And again, you do need to honor both the word and spirit of that sort of arrangement, but that language has been slipped into even non-sell-in scenarios as well. So something to be aware of that might need to be identified. You also need to worry about potential privacy policy issues, both from a Reg SP, which is an industry privacy policy language or regulations, and then your firm might have specific privacy policy language that you need to be familiar with, primarily related around maybe what client information you can or can't take on the way out the door. So that privacy policy variable is very important to understand as well. Kind of related to that is the broker protocol. So for those of you that are familiar with the broker protocol, I did a separate episode on what that is. Under certain circumstances, and it's beyond the scope of this episode, but under certain circumstances, there is a mechanism where you could potentially kind of free and clear, without any issues, take certain pieces of client information with you with the full understanding of the firm you're leaving that you are doing that. There's very specific rules around that. They have to be followed to the T. But if it's available to you, that might be advantageous for you to utilize. So that's another example where you'd want to understand, hey, is this a potential broker protocol, as the phrase goes, situation that I could either take advantage of or that I need to be mindful of, that if I were to do it as such, there's specific rules related to that as well. Another variable that could be in your agreement is oftentimes advisors and teams want to take team members with them, administrative staff or sales assistant staff kind of things. If you're at a W-2 firm now, as is kind of common with a lot of any occupation where you were employed by someone, oftentimes there could be language about not solicited employees of that firm to leave the firm and go in whatever direction you're going in life, whether in this case to an RIA, or if you're starting some other business, though, you're not supposed to solicit employees away from this employer. And that's often kind of in there by boilerplate. It's not to say that can't be navigated. I'm not suggesting you can't ultimately have team members come with you, but you would want to be aware of, do I have language in my agreement about that? And if I do want to bring team members with me, how best can I navigate that to make sure I'm not going to create issues for both myself, the team member, and then I don't want the firm obviously coming after me because of that. So again, depends on if you want to take employees with you, is something to be mindful of. Another thing, and these are not in any particular order, is if you have outstanding stock that you've been granted, sometimes called RSUs, restricted stock units, or you've been granted equity, those stock units or equity perhaps is not fully vested yet. And if that's the case, you certainly would want to understand, okay, what exactly happens if I leave on this time period, and here's the vesting arrangement of those shares. What do I get to keep? What do I not get to keep? And even if you feel you are fully vested in perhaps RSUs or equities, unfortunately, I have seen scenarios where an advisor team, there's one specific that I can think of, that they thought they understood that fully, what their situation was, and that they had equity and that they were fully vested, and there's no reason to worry, they can leave and that equity can go with them. Well, it turns out there was language buried in an agreement they signed along the way that, and I forgot what the exact terms were, that basically said, hey, if you leave us and you don't give us, and I forgot what it was, say a 15-day notice that you're going to leave, which is not normal. Normally you leave and depart right away after given notification. But in this case, they had slipped in years later after the original equity grant had been made, some language that if you don't give like this 15-year window, that you automatically forego and lose that equity. Obviously, that could be problematic if you're under the assumption you're going to have this equity as part of your wealth, part of your assets going forward. And it turns out there was some clause in an agreement that you didn't catch or that you didn't navigate correctly, and that could be very damaging as well. So equity, RSUs, that sort of thing is to be mindful of. Other folks with deferred comp, if you're at a large W-2 broker-dealer type firm, unfortunately, you probably do have deferred comp. And by nature of how deferred comp is designed, you're kind of on this roll investing period where at any given time, you always have some amount of that is unvested. The only way to fully vest all of it is if you ride out your career there typically and retire from the firm and go through their often called sunset program. And short of that, along the career track, you typically do have unvested portions of that. I've done an episode on how to kind of economically overcome the fact that you're going to lose deferred comp and how you can kind of manage that going forward on your new path in the RIA space. But you would want to be aware of, okay, what is my situation with my deferred comp? And whatever your assumption is of what you will or won't be able to keep, is that accurate? Again, that's something you want to talk with the attorney about. I just referenced typically the only way to kind of ride out deferred comp fully is if you stay at the firm and then go through their kind of exit program, sometimes referred to as a sunset program. Well, another variable to consider is if you either recently or even long ago perhaps were on the receiving end of a retiring advisor's practice as part of one of these sunset programs. Typically, that's something you navigated with that advisor over several years, and that advisor is paid out over several years. And even if that's fully ran its course, or maybe you're still in the middle of that, along the way, you might have signed some sort of agreement that had some language that then restricts in different ways than just your traditional agreement some of those client assets. So if you've been on the receiving end either recently or even a long time ago of one of these sunset programs that retire an advisor's assets, that's another reason you want to go over that with an attorney as well. And then the final two things with respect to kind of language and agreements. One, if you are still within your initial, if you join the firm you're at now and they wrote you a big check on the front end, those are typically tied to what's often just referred to as a forgivable loan, particularly say the big wirehouses that might be give or take a 10-year loan period. Well, if you're still in that period and you leave, obviously they are going to want some of that money back. Technically, you're just repaying the unpaid balance of the loan at that point, but you are going to want to fully understand, okay, what exactly will I owe back? What is the expectation of how quickly the firm's going to want it back? And how can I try to make that process as smooth as possible to not give my prior firm any sort of ammo to otherwise come after me? So if you do have that, I don't want to say unvested because that's not really what's happening with that, but you're in that loan, that forgivable loan period, you're going to want to be mindful of that as well and talk to the attorney about it. And then, like I said, the last piece just on the agreement, this is not an exhaustive list, but hopefully you see there's a lot of potential variables here. But the other one is if you've potentially at a firm and that firm has been acquired by another firm and you sat tight and went along on the ride to the new firm and you got some sort of retention bonus from it, you signed something when you got that retention check. And typically there's language in there that you want to be mindful of, perhaps a certain period of time before you may or may not owe some of that money back, or are there other restrictions associated with that? So if you've got any sort of kind of upfront bonus, we'll call it, or some sort of retention bonus, again, you want to be mindful of that. That's a thing that an attorney can help you kind of navigate. So those are some of the variables that are in potentially, agreements in writing that you've signed off on that you potentially want to be mindful of. Again, most of you are not going to have all of those by any stretch of the imagination, but even if you have just 1, 2, 3 of them, hopefully you're understanding by my comments here why it's important to make sure you fully understand them and fully navigate them correctly. But some other things that these attorneys can help you with beyond just what's in those agreements is also, which is very important, is they will coach you on, based on whatever your agreement situation is, what you can and can't say to clients after you've left. So for instance, if you have a non-solicit, you're not going to just call a client up and the first thing you say to them is a blatant solicitation. I've started a new firm, client, I'd love you to come join me at the new firm. Arguably, that's a solicitation. So there's a way to navigate around that there's precedent set of what is or isn't typically considered a solicitation. But it's important, again, based on what your agreement is, that how you communicate with clients initially after your departure is very important. And that's a big part of what these attorneys will help you and coach you on. Related to that is also when you can talk to your clients about this. Now, in every instance, the short answer is you do not talk to clients at all about this until you've resigned from your current firm. You don't talk to them ahead of time about it. And that's for your protection. That's to not involve the client in any potential issues that your firm might want to try to bring up. But some of you, I get it, are saying, hey, I'm already out an independent broker-dealer. I'm already independent. I should be able to do that. Well, again, the devil's in the details. What kind of firm are you at now? What have you maybe signed or not? The attorney can try to help you understand where you'd be on that risk spectrum. Obviously, it's easy for them just to say, kind of what I did, is say, don't talk to clients ahead of time. If you are insistent, perhaps some of your biggest clients, at least you'd want to hear what the attorney has to say about what risks that might be bringing upon yourself if you were to do that. So again, when you tell clients is also important. It's also important to work with the attorneys to know what documents, what client information, what client documents you can take with you. I alluded to earlier, like the broker protocol. And if you were doing a protocol transition, as they say, there's very specific information you can and can't take. And even with the broker protocol, you have to notify your firm of the information that you've taken. Other firms, you might be able to take more than that. But again, it's very specific to your situation, the firm you're at now, when you join them. Perhaps things have changed over time, and all those variables I talked about. So don't have, just because you've known someone that's left your firm before and they did X, Y, and Z with the documents or information they took, maybe they got lucky and it just wasn't an issue for them, and maybe they shouldn't have done that, or maybe they were allowed to do that, but your situation might be different. So again, understanding what client information can I take with me is important as well. And then the last item I'll just point out for here, and this seems like kind of a smaller item, but it's still important, is literally how to resign on the day that you've mapped out that you were going to do so. And so that's literally from how to notify your firm that you've resigned. And also you'd say, well, that's real simple. but it can be complicated because what happens if there's multiple advisors on your team? Okay, are you all resigning simultaneously? Does someone start first and then other people follow? Well, what about those team members that you're hoping to bring along? And again, you got to navigate that. Are they resigning on that same day, or are they waiting a couple of days to resign? So when and how you resign is another important variable you want that legal advice from. So the reason I say all this, again, is just to point out that this is just an important step in any transition, is getting that advice. And the key is, or the good thing is, there are specialty attorneys that this is the main thing they do, is help advisors navigate the departure from their current firm. So I sometimes hear folks, because I bring this up almost every instance, and say, hey, do you need legal advice? Have you begun that process? And sometimes advisors will say, oh, I have a buddy that looked at my contracts and gave me feedback. Well, it turns out the buddy is like the college roommate that, yes, went to law school, but is like a personal injury attorney, not a contract attorney, and certainly not someone that knows our industry. So you do want specialized advice, and there are specialized attorneys that can provide that advice. So you might as well go to them for this sort of thing. And part of the benefit of these folks being specialized is that the good ones that have been doing this a long time have done this hundreds and hundreds of times. Some of them do hundreds per year. So they know, hey, based on the type of firm you're at, this is typically how your firm might react to you leaving, and these are the things we want to be extra sensitive to or be extra precautious about. And so you get to benefit from their years of experience doing this with hundreds and hundreds of advisors that have come before you. There's no reason for you to reinvent the wheel on this. Benefit from all the experience that they have. Now, another part of the experience they have is in oftentimes advisors and teams understandably don't have a copy of something they signed, sometimes because they joined the current firm they're at 20 plus years ago, and they either never got a copy then, or they got a copy and life has gone by for 2 decades, they've moved, and they have no idea where a copy of that is. That's not as ideal, obviously, as knowing or having a copy, because the attorneys would like to see a copy of what you have. But if you're in that scenario where you do not have a copy, the next best thing is these attorneys, because from their experience and having done this so much, typically will be able to kind of look into their vault, if you will, and say, hey, okay, based on the firm you're at, based on the time you joined that firm, our experience says, from having done all these other ones, from advisors in that exact scenario, you likely signed an agreement with this language in it, and you can benefit again from their knowledge of that. And for those of you that can't find your agreement, that's going to be very invaluable. That's the next best thing, is they can try to draw that out as best as possible. And then the final thing, if it's not apparent to you, but I need to point out all these possible times you might need the legal advice, it's just a cost of doing business to do a transition correctly. There are a lot of things that have to be solved for as part of a transition. There's a lot of moving parts. There's a lot of cost involved. Now, obviously, I've talked about in different episodes why all that effort and all that cost and all the work you go through a transition is generally always worth it on the other side. That's the big thing of what I help advisors with, is what will that other side look like? And let's make sure that the journey is going to be worth the destination. But legal is kind of one of those just requirements. And if you're not able or willing to spend typically a couple $1,000s at least on attorneys to make sure you're going to depart your firm successfully, you probably shouldn't be making the transition. As I said, it's just a cost of doing business, a cost of doing a transition successfully. So with that, like I said at the top, my name is Brad Wales with Transition to RIA. This is the sort of conversation I have with advisors all day long. While I am not an attorney myself, but I help you fill in all the gaps, or understand all the gaps and all the steps in this process, and help you understand why and how legal advice is generally needed. And I can help put you in contact with these specialty attorneys to fill that bucket in the process. Again, I can't stress enough how important that is. If we have a one-on-one conversation with each other, you will hear me say it again to you directly. It just is a very important thing that you need to consider and you need to solve for. But first things first, head on over to the website, transitiontoria.com, where, as I said at the top, you can find this entire series in video format, podcast format. There's articles, there's white papers, there's a vendor profile series, And at the top of every page is a contact link. Click on that and you can instantly and easily schedule time to have a one-on-one conversation with me, whether you want to talk about today's topic or anything else RIA related. I'm happy to have that conversation with you. Again, transitiontoria.com. And with that, I hope you found value in today's episode, and I'll see you on the next one.